Alex here with part 75 of the My Docket series on child custody and visitation. As with my previous video, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose behind the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So, we left off in part 73, we're going to skip over one, with the Supreme Court's affirmance of the decision entered in my case against the Secretary of State. I was trying to get my ex's fictitious address canceled. In that appeal, I had come to the conclusion that the correct vehicle, the correct approach, was a writ of mandamus. And I had asked the Supreme Court to please just construe the petition that I filed as a petition for writ of mandamus. They refused to do so. They affirmed the lower court's decision, and that left me with one of two decisions. The first one is for me to just give up and walk away, and the second one is for me to file a petition for writ of mandamus. And that's what I did. I went with the second one. Now, I would rather talk about the details of the filing in the later part of the video where I actually go through the petition itself. But I do want to mention something here before I even get to that point. There were two ways that I could have done this. I could have filed the petition for writ of mandamus in the district court first, and that was the appropriate thing to do. But I didn't do that. I filed it in the Supreme Court directly without going to the district court first. They don't like doing, they recommend you don't do that. They state that they will consider them under certain circumstances, and one of those circumstances is that you, well, actually it's not under one or two, it's actually that I think you have to satisfy both circumstances. There's two things that you have to satisfy both, and if you don't satisfy them both, then they will not consider what they call an original petition for writ of mandamus. One of those is that it has to be an issue of statewide importance. And that's kind of what I was arguing. I was arguing that this is a fictitious address program. It's going to implicate the rights of parents throughout the state anytime their ex gets a fictitious address. And so I tried to make it a bigger deal than just me. I tried to basically tell them, you're not just helping me, you're helping the entire state. All of the fathers and mothers who are going through this particular problem that I'm going through need a decision here. The second is that you present to the court pure questions of law. Questions that do not require any consideration as to the facts and circumstances of what's going on. That's kind of where I went afoul of those two requirements, and even though I did file it in the Supreme Court and shouldn't have, they still considered my petition and they still published the case. So I got really lucky, because they could have said, no, this still involves issues of fact, we're sending it back. But they didn't do that, and I think the reason why, it's not just to be nice to me, it's not that they kind of wanted to help me out, it's that I think they really did think it was a serious issue, that it was going to implicate the parental rights of a lot of people, and it's a fundamental constitutional right that you have, a part of your child's upbringing. And I think that they also understood that there wasn't anything out there explaining how the process was supposed to work. In fact, when they do finally publish the decision in this case, they literally create the process. In the published decision, it states that from now on, this is the procedure that you are to follow when this particular thing happens in the future. So on the one hand, it's nice that they did that, but it wasn't just them being nice. They wanted to actually deal with this legal issue. Then on the other hand, I should have probably still just filed it in the district court first. It also would have affected the impact, because when they finally publish their case, the procedure that they create requires fact-finding, and so for that reason, they have to deny the petition. They create the procedure that I can then use after the denial, which I do use. I filed a case in the district court after they published the decision, and then that district court uses the Supreme Court's published opinion and grants my request. They cancel my ex's fictitious address. But had I done it the more appropriate way, it would have sort of looked better. And what I mean by that is, what it would have looked like is like this. I would have filed a petition in the lower court. They would have made the mistake that they made in the previous case for sure. I'm not at all thinking that this judge would have figured out the correct thing to do. He would have just denied the petition, just like he did in the other case, and then I would have filed an appeal to that order denying. and then that appeal would have gone to the Supreme Court, and then they would have reversed. So the labels would have been different, and the procedure would have been more consistent with what they expect of attorneys. But all of that being said, it's just a bunch of technical legal jargon, I think, to a lot of you. Maybe some of you understand what I'm talking about, especially if you've seen some of my videos on appeals and writ petitions. But if you haven't seen those videos, it's going to be probably really confusing, all that stuff I just said. But I do want to mention that even though I took this approach of filing the petition for writ of mandamus directly in the Supreme Court, it doesn't mean that you should all do something like that as well. If you are bringing an issue in an extraordinary writ to the Supreme Court's attention and it involves fact-finding, typically they expect you to file it in the lower court first. And I suppose, with all of that being said, we can finally go ahead and take a look at what I have filed. Here we have the petition for writ of mandamus. It's considered an original petition because it is not on appeal from the lower court. I filed it straight into the Supreme Court. My petition identifies myself as a petitioner and the government, or the Secretary of State to be more specific, as a respondent. First thing I want to mention here is a lot of times when you file a petition for extraordinary relief, you're going to have what they call a real party in interest who is impacted by whatever it is that you're trying to do. And in this particular situation, it's my ex. So even though the target of my lawsuit is the Secretary of State and not my ex, the outcome of the lawsuit would impact my ex's rights because she's the one that has a fictitious address. And so I should have included her as a real party in interest. The Supreme Court takes care of this later on in the case. They get her horseshoed right into the Supreme Court case using their own powers. And we'll talk about that when we get into it. But for now, I'm just going to let everybody know that I should have sued both a Secretary of State and my ex with this petition, and that my ex should have been listed as the real party in interest. Okay, so pursuant to Rule 21, I am asking for the Supreme Court to issue a writ of mandamus commanding the Second Judicial District Court. This is confusing. This is wrong. So this should say here that pursuant to NRAP 21, I petitioned the Supreme Court of Nevada for writ of mandamus. So I don't know. Maybe I originally planned to file this in the lower court, and then I changed my mind. That's what this makes me think. This makes me think that I meant to file it in the lower court, and then at some point I figured, nah, I'll just file it in the Supreme Court instead and see what happens, which again is not recommended. It's based on the appendix and exhibits on file herein. Memorandum of Appointments and Authorities. We have persons of interest. So we have myself, the natural father, my ex, the natural mother, the government, which issued the fictitious address to conceal my ex, and then our child, who is a minor child of age 5. Related cases, we got the custody case, we got the temporary protective order case, we have the petition for judicial review that I filed, and we have the appeal to the Supreme Court of Nevada, which in Part 73 ended in a loss. Issues. So the first issue, by the way, these sections here, like issues, procedural history, related cases, this kind of stuff, I strongly suspect that these were outlined in the rules of appellate procedure. I might be wrong. I might have added a few in there sort of to spice up the paper, but my understanding is that opening briefs, answering briefs, reply briefs, fast track statements, etc., that the Supreme Courts of all 50 states and the appellate courts as well have rules of civil procedure or rules of appellate procedure that specifically state what they expect to be inside of these filings. And so definitely take a look at your rules of appellate procedure. Don't just kind of copy off what I did here, because your state might have different requirements, different things that they expect to be in the brief that you're filing. Anyway, issues. The sole issue upon which this case hinges is whether the law authorizes the government to issue a fictitious address to an applicant based on the mere existence of a protective order, or whether the law requires the government to consider the substance of a protective order and search for specific evidence of domestic violence having occurred before issuing the protective order. And it's kind of, what I'm basically saying is there are two possibilities here. Number one is that if the government gets a protective order, then that's it. They just have to give my ex the address. Number two is that it's not enough. If they get some kind of document from my ex, they have to do some investigation. They have to look further. And so I'm trying to sort of bring this to the court's attention as the Secretary of State needs to do more than just accept a protective order and give out a fictitious address. Now, I end up being wrong about this approach, but I end up being right in the end for different reasons. And the Supreme Court will pick apart why my request for relief is more of a constitutional one, it's more of a due process one, and less of the Secretary of State has to do more work, more investigation. We'll get into that more when we get to their order. Procedural history. So, let's see. I sued my ex for custody. My ex sued me for the temporary protective order. The court awarded us physical and legal custody jointly. I asked for a petition for judicial review against the government, and that's, of course, the other case that I'm talking about. The Second Judicial District Court dismissed my claim on the merits. I appealed to the Supreme Court of Nevada, and then the Supreme Court of Nevada affirmed the lower court's order for a different reason. They rejected that the case should have gone to the merits at all and indicated that the case should have been dismissed for lack of jurisdiction. Factual background. So we have the 2005 entry into the relationship, the 2007 attempted suicide, and we've got the exhibits, which are the police reports that were filed. We have my ex's attempted suicide, which led to the dissolution of the relationship and the bitter custody battle which ensued. And then we have my ex's application for a fictitious address, which the government granted. Now we get to the argument, or the law. The appellate forum is appropriate for pure questions of law, and that's what I was talking about earlier in this video. I cite a case here, Round Hill General Improvement District versus Newman, which states that an appellate court is not the appropriate forum in which to resolve disputed questions of fact when there are factual issues that are critical to demonstrating the propriety of a writ of mandamus. The writ should be sought in the district court first, with an appeal from an adverse judgment to this court. This is what I was talking about earlier in the video. What I should have done was filed the petition for writ of mandamus in the lower court, lose the case, which is what I know would have happened, and then file an appeal from that order denying. That would have been the best way to approach this problem. I still end up getting through it. I still end up winning the case, but it was something that was really risky, and it's not something that I recommend any of my viewers do. It's better to follow this procedure here. So they ultimately get to the conclusion here where they will exercise their discretion to entertain a petition if important public interests are involved and if there are legal rather than factual issues being presented. The government maintained its position throughout the previous case and appeal that the mere issuance of the protective order is sufficient to grant a fictitious address. The record aside, the law limits the government's review to the application filed, the time before its filing. This required the application provided by my ex. This required application provided by my ex was disclosed by the government. Reviewing the application reveals that she attached a protective order, and I agree that the protective order is genuine. Therefore, all of the material facts are in agreement. All that remains are questions of law, which will be addressed below. Now, I am talking about the extraordinary writ itself. A writ of mandamus is available to compel the performance of an act that the law requires or to control an abuse of discretion. I cited a case here, State ex rel Masto versus Second Judicial. And the law authorizes the government to issue the fictitious address to victims. I'm holding that the government abused its discretion because it issued the fictitious address to my ex without abiding by the requirements of the law, which requires specific evidence showing that she's actually a victim. This is what I've been talking about for who knows how many of my Docket videos. I'm finally getting to the point where I can get this issue addressed. Exploring alternative vehicles. So that same case, State XL Masto versus Second Judicial, discusses that extraordinary remedies and the decision to entertain them is solely discretionary with the Supreme Court, and in general they will only do so when I have no plain, adequate, speedy legal remedy, such as an appeal. So in considering whether I should file this, I indicate that I have sought possible alternative vehicles. First, I questioned whether or not to appeal the entry of the restraining order against my ex. The court granted her restraining order not on any specific evidence that domestic violence occurred, but purely on her allegations and speculations that it might one day occur. And the requirements for issuing a protective order are stated under the law, and those indicate that she can get a restraining order when there's a threat. In other words, she doesn't have to show that she's an actual victim. So I'm basically indicating here that I thought of this and that it wouldn't have worked. I couldn't file an appeal for her getting a restraining order for not being an actual victim because, according to the law, she doesn't have to be an actual victim. She just has to show she might one day be. So that appeal would have failed. The second possibility is that, let's see here. If her allegations are so serious that I'm such a dangerous person, then I wouldn't be able to get physical custody of our son. So somebody would presume that I, having been awarded physical custody, would be able to seek some kind of remedy in that specific case, which is the child custody case. The unfortunate truth, however, is that the law is entirely extrajudicial. It doesn't involve the judge at all. All she has to do is file an application with the government, and just like that, voila, she gets her fictitious address. So that possibility there is just another thing that wouldn't work. I wouldn't be able to ask for the judge in that specific case, in my child custody case, to somehow order the government to do something, because the government is operating under completely different legal structure, legal framework, and the government is following the rules as provided by the legislature in that totally separate framework. Finally, there is the petition for judicial review. I tried it, didn't work. I filed a case, lost the case, filed an appeal, lost the appeal because they said that you can't do that unless there's a contested decision. So those are all three options that I felt I had at the time. None of those three options are viable, and that leaves the government to issue a fictitious address as it feels it can without any kind of scrutiny from the judiciary at all, which leaves me with only one possible remedy: the extraordinary relief that I'm requesting in my petition seeking a writ of mandamus. Now we've got the next section in my legal analysis, which is the fundamental liberty interest. The Supreme Court of Nevada acknowledges the fundamental liberty interest between a parent and their children. And that's in the case Champaign v. Welfare. It later the Supreme Court of Nevada referred to parental rights as sacred. And the Supreme Court of the United States stated that the absence of dispute reflected in their historical recognition that freedom of personal choice in matters of family life is a fundamental liberty interest protected by the 14th Amendment. So I'm basically tying the United States Constitution into this case. I'm arguing that this issue that I'm bringing to the Supreme Court's attention is important because it's a 14th Amendment issue affecting our fundamental liberty interests as parents to be involved in our child's upbringing. Next, we have the final paragraph in this section, which asserts that under certain circumstances, the liberty interest has to be infringed, such as the intention of the legislature by passing that law protecting victims of domestic violence. But I am of the belief that the legislature took great care in ensuring that the liberty interest was only infringed when necessary, and that the constraints are described by the law, requiring the government to find that my ex is actually a victim, and that by not doing so, the government violated the law and the intention of the legislature. And if not, then the government violated the liberty interest of a natural parent under the 14th Amendment. So it's one of those situations where they're damned if they do and they're damned if they don't. Either they're not complying with the law, and therefore I need mandamus relief, or they are complying with the law and it's in violation of the U.S. Constitution. So it's just one of those situations where I have the government cornered. Next assertion here is that there is a violation of the law itself. The law provides that the Secretary of State shall approve an application if it's accompanied by specific evidence showing, and then they go into this list: record of conviction, temporary restraining order, other protective order, blah, blah, blah. And then I've got the other statute here, which indicates that an application for an issuance of a fictitious address requires that, in this particular situation, my ex has been a victim. It's in bold and it's in black. So these two statutes here conflict. There's one statute that says she has to be an actual victim, and there's one statute that says she has to provide one of these pieces of evidence. She's provided this piece of evidence here, the temporary restraining order. And I am arguing that the manner in which she obtained this is inconsistent with this other law over here. So this is the kind of stuff that the Supreme Courts are supposed to get involved in. You have these two statutes with language that's contradictory or language that is conflicting. And you need them to step in and create some kind of rule going forward that deals with those conflicting statutes. The government has held that because the law provides that a protective order is one of the pieces of evidence that they can rely upon, that they are therefore able to give my ex fictitious address. And that makes sense until you get to NRS 33.020. The problem is the statute that governs when somebody gets a temporary protective order. And that's what I talked about earlier in this document, that you can get a protective order without being an actual victim. And that's what I'm going to argue has occurred in this case, and that's what's going to lead to the Supreme Court agreeing with me that we have a problem. So here I go into a case that discusses legislative intent and statutory construction. I would get really technical at this point in the video if I hadn't dedicated another video to this topic already. If you want to know more about statutory construction, why it is an integral part of analysis by the Supreme Court of Nevada or any Supreme Court of any state, please watch my video, Statutory Construction. I explain all of the different rules, the plain language rule, how they deal with ambiguous statutes. All of those details are covered in the video, Statutory Construction. And in a nutshell, that's what I'm trying to do here. I'm trying to get the Supreme Court to accept my interpretation of these two conflicting statutes. And as we proceed through this process, through this petition, this writ relief that I'm requesting, the government is going to come up with their own interpretation as to what they want going forward. Or I think they actually just argue for dismissal of the case or denial of the petition itself. We'll see when we actually get into that part of the series. Argument in support of costs. So I'm arguing here that I am entitled to an award of costs if I win this case. And we could talk about this a whole lot more. I already have another video on the topic though, and we are going to eventually get to some cost motions that I win in the series. So for now, I'm going to glaze over my request for an award of costs, and what I'll do is instead direct my viewers to the video, attorney fees, and costs. I talk much more about my successes in that particular area when, if you watch that video, and then later on in the My Docket series, you're going to see at least 2 occasions where I win an award of costs. Conclusion. Here I am, just including my prayer for relief. I'm asking the court to issue a writ of mandamus directing the Secretary of State to revoke my ex's fictitious address, and I'm asking for an award of costs. My verification in support of the petition, I'm basically taking all of the factual assertions that I have made in this petition, and I am swearing them under oath, under penalty of perjury, and that's what this signature is right here, and that's what this specific sentence, I declare under penalty of perjury that the foregoing is true and correct. That's what this is doing. It's turning this into a declaration in lieu of affidavit. If you want to learn a little bit more about what I'm talking about there with that little technicality, please watch my video, Declarations and Affidavits, because in Nevada we have a statute that says if you include very specific language verbatim into a document that you're filing with the court, that converts or allows the court to treat that particular document as an affidavit, even though it's not stamped by a notary. Affirmation pursuant to the law, and this is just letting the clerk of the Supreme Court know that this does not contain the social security number of any person, or at least that I'm swearing as much. Why is this included here? This is the proof of service. This shouldn't be here. This should be a separate filing. So it probably got stuck to the back of the petition, and they just assumed it was all one document. It probably gets dealt with later on, but it's strange for it to be here like this. Here we have my appendix to my petition for writ of mandamus. Okay, all of these exhibits that are included in this appendix have already been gone through in the My Docket series. Every single one of these filings is part of the record in the lower court, and so there's not really much else that I have to do. I don't want to go through these because I've already gone through them. So what I'll do is just mention that an appendix is it's like what it's hard to explain. It's not like an exhibit. See, there's a few things that I feel like I haven't done right here. First off, an appendix needs to have an index. And second off, it's a compilation of the record in the lower court. It's not really supposed to be something where you include new exhibits that the Supreme Court has to consider because, as I mentioned earlier in this video, they're not fact finders. They don't want to review a piece of evidence and make a finding of fact on it. That's up to the lower courts, not the Supreme Court. And so these appendices, what they're supposed to contain is things that have already been considered by the lower court. Orders and documents and other evidence that's already been submitted and considered and findings have been made upon them already by a lower court judge. And so some of these documents here are allowed to be in this appendix. So these police reports, for example, were attached as exhibits to many of the lower court filings. Court orders, application by my ex, these have all been included in filings in the lower court. They're part of the record of one of the two lower court cases, the child custody case we have in one hand, and we have the petition for judicial review that I filed on the other hand. I have a suspicion, though, that some of these are not appropriately in here. It looks like at first glance it's okay for everything to be in here. These are cases, published cases. I'm not sure why I included them into the appendix. I don't think that's required. I think I could just cite to the case. Anyway, the appendix typically has to be built according to the rules of appellate procedure, which I don't think I followed because, number one, we don't have a table of contents. And number two, we don't have the page numbers. Number three, these are supposed to be bait stamped. Let's take a look and see if they are. Nope, there's no bait stamps. So I'm supposed to have them bait stamped. These exhibit partitions aren't supposed to be in here at all. So there's just a lot that I did not do correctly. This is an appendix that I just kind of guessed how I was supposed to put it together. I probably just assumed it was like any other filing in the lower court where you just add exhibits to the back of it, but that's not how it works at all. I think I'm going to spend a lot more time on the appendix when I get to one of my later filings where I actually file it correctly. This is an appendix that I just kind of winged it, I guessed, and it's not filed correctly at all. It is a document that will be referred to, or it's supposed to be referred to anyway, by an appellate court. And the last thing I really want to mention is that normally in Nevada, if you file an appeal, you don't file an appendix at all. The lower court is required to put together the record on appeal, and they're supposed to send it up to the Supreme Court. At which point you can refer to it all you want in your briefs. If you're an attorney, you don't get that kind of benefit. You have to prepare the appendix for yourself. But all of that, that's for appeals. I'm not filing an appeal here. I'm filing a petition for writ of mandamus. It's an original writ petition. And so I do have to, even though I'm unrepresented, prepare an appendix. I'm required to do this as an unrepresented party. Now, I don't recall the Supreme Court of Nevada saying anything about this appendix being inappropriately put together. They kind of just go with it. But I do want to mention to my viewers that the way in which I put it together is not correct, and that oftentimes a non-attorney will put things into their appendix that are inappropriate, things that haven't been considered by the lower court. I gave this thing a cursory glance, and I can't see anything in here that's not appropriately inside of it, but I do want to go ahead and go through all of those disclaimers and my full explanation as to what this is and why I'm not going to go through it any further. And if any of my viewers have any questions on the appendix, just like with all my other videos in the My Docket series, you can go down in the description below, click on the link, download it for yourself, look through it. And if you have any questions, just post it down in the comments below, and I will go ahead and address that when I actually see it down in the comments. Moving on, motion for expedited review. I think I've done this before, and I usually recommend not doing it. If you're going to ask for something to be considered under the emergency rule, you should follow the emergency rule. There is a rule in the Nevada Rules of Appellate Procedure that explains how emergencies are supposed to be brought to their attention, and I'm not doing that here. I'm just asking for expedited review, which as far as I know is not a thing. I know I'm citing Rule 27, but I'm sure that Rule 27 is the rule that covers criminal and child custody appeals or child custody writs. And so if I remember correctly, that is just something that automatically takes effect. You don't have to file a motion. It just automatically happens. When they find out that you have filed some kind of appellate challenge to a criminal case or a child custody related case, they automatically on their own will expedite review of the case. You don't have to do anything special to get that to happen. So I'm not going to spend a lot of time on this motion, but for the most part, I'm asking for the appellate court to expedite review of this petition for writ of mandamus. Because in hindsight, I don't recommend having filed this in the first place, I'm just going to skip through it and just reiterate for my viewers that I filed something that I shouldn't have filed. And that had I, had the experience then that I have now, I would have never filed this. If you want to know more about emergency petitions, I think I have a video on the topic. Take a look through my channel for a video titled Emergency Petitions and Emergency Appeals, something like that. And I go ahead and I go through how the rule of appellate procedure on emergencies works in Nevada and what you're supposed to do to get emergency review. That's the appropriate way to deal with a problem like this. Now, do I think this is an emergency where I should get emergency review? Having thought about that, no. I don't think I would have sought emergency review then, even had I known that that's the correct approach. I don't think that the Supreme Court would have entertained this under the emergency rules. I can see how you can kind of, as a parent, you can kind of turn anything involving your kids into an emergency. You really can. It's not that hard to see something that your children need as an emergency. They're children, they're vulnerable, they're your kids. And it's one of the things that I think all judges in the Supreme Court and lower courts see all the time, and it frustrates them. And it takes a long time, several years of representing yourself to really figure out what the judge is going to consider an emergency versus what you're going to consider an emergency. Next document, we have the notice of change of phone number. In this so it's basically me taking the same approach as I take with the notice of change of address. I don't think you have to do this. It doesn't really hurt. I guess it's helpful for the court to know your phone number has changed. I don't know. I mean, probably wouldn't have filed this in hindsight if I had the experience then that I have now. I would have probably just sent an email to my ex's attorney, or in this case, I guess the government's attorney, indicating that my new phone number is such and such, and that's that. I don't think this warrants filing a piece of paper into the docket. Notice of, or Rule 5, Certificate of Service. I shouldn't have used this rule. It doesn't matter because there is I guess you can call it a mirror rule in the rules of appellate procedure that, for the most part, allows for the same exact way, the same exact manner in which to serve my adversary. But Rule 5 doesn't apply in an appeal. You have to use the rules of appellate procedure. Proof of service. Why is this stuck to the other document? This is supposed to be a separate filing, and they've stuck it to the back of this document. So I think it's just another mistake by the clerk of the Supreme Court. They didn't, I know for sure they weren't stapled together, but they might have stuck together somehow and confused the clerk of the court. Anyway, this is just my process server indicating that this particular petition was personally served upon the Secretary of State. I still doubt this. But this is a third party. This is another person. So maybe I did send him all the way to Carson City. It's more believable than if it was me. If I signed it, I would suspect that I just kind of made a mistake and that I actually mailed it to them. But since I sent an actual process server, it was probably personally served. Notice of my ex's non-opposition. Notice of the government's non-opposition. So what I'm doing here is I'm indicating to the Supreme Court that the government was served with a motion under Rule 6. Okay, under Rule 6, the government was supposed to oppose the motion and that they didn't do this. And then I'm citing Rule 13.3, arguing that a failure of the government to file and serve a written opposition can be construed as an admission that the motion is meritorious. Okay, DCR, that's District Court Rule 13.3, that doesn't apply here. Only the Supreme Court rules or the rules of appellate procedure are going to apply here. Now, that being said, I'm pretty sure that there is a rule of appellate procedure that provides virtually the same exact thing, but I do want to let my viewers know that when you're in an appellate court, there's often a different set of rules that apply, and my reliance on the rules of civil procedure, I did that too. So NRCP 6 and my reliance on the district court rules, DCR 13.3, is misplaced because we're not in the district courts, we're not in the justice courts, district courts, we're not in the lower courts at all, we're in the appellate court, the Supreme Court of Nevada. So it's not going to really matter. I don't think that this is the basis that they grant the motion anyway. I think they just automatically expedite these appeals because they involve child custody issues, and so nobody really cares. The government doesn't care. The Supreme Court of Nevada doesn't care. I'm just not sure of this because I'm representing myself and I don't have the same insight that I have now, and so I'm just kind of wandering aimlessly through the appellate court, hoping that I get everything done correctly. Notice of appearance. So the Attorney General, Catherine Cortez Masto at the time, that's not the Attorney General anymore, and Solicitor General Wayne Howle are giving notice to the Supreme Court of Nevada that they have appeared on behalf of the government. Secretary of State Ross Miller at the time. He's no longer the Secretary of State. Future pleadings need to be served upon these attorneys, which makes sense. That's what happens when an attorney files a notice of appearance. They're indicating that they serve this to me by mail. Here we have the Supreme Court of Nevada's order directing supplemental responses and answer. The Supreme Court of Nevada is recognizing my proper person petition that I filed, challenging the government's issuance of a fictitious address under the law. As an initial matter, my petition challenges the issuance of a fictitious address to a third party who is not a party to the proceedings. This is what I was talking about earlier, that where they're going to sort of shoehorn her into the case, my ex. These proceedings could possibly result in the revocation of her fictitious address, and there can be an issue as to whether or not the matter can progress without giving her an opportunity to participate in the proceedings. Accordingly, the Supreme Court is directing both me and the government to file within 11 days from the date of this order a response addressing whether or not my ex, as a recipient under the law to a fictitious address, is an indispensable party to the proceeding. Having reviewed the petition, it appears that I have set forth issues of arguable merit and that I may have no speedy or adequate remedy at law. Therefore, the government is going to have 30 days from the date of this order to file and serve an answer, including authorities against the issuance of my requested writ. So the Supreme Court of Nevada is telling the government that they will be forced to respond to my petition, and that I have a right to, within 15 days of service of their answer, to file a reply if I choose to do so. I have filed a motion for their expedited review of the writ petition since the matter involves child custody, and to the extent permitted by the court's docket, they will expedite consideration of the writ petition. Here is my response regarding the third party. This is regarding the previous order the Supreme Court entered. I'm filing a response to the court's order December 28, 2011 as to whether or not my ex is an indispensable party. Going into points and authorities. Number one, I'm arguing that she's not an indispensable party. Let's see why. Under this case, I'm citing Potts v. Docket. An indispensable party is a party who is necessary to an action, but who for some reason cannot be made a party to that action. While my ex would undoubtedly be affected by the revocation of her fictitious address, her rights under the program would remain unaffected because her right to use the fictitious address program is not being challenged, merely the government's interpretation and execution of the law. Here's the law that I was talking about in my brief, which says she has to be an actual victim. Even though she prepared the application submitted to the government, I am not and have not challenged her position that she feels subjectively that she's a victim. Any array of emotions could have provoked her to feel this way, and possibly she perceives she has been. It's still her responsibility to understand the statutory definition of domestic violence. I could have perhaps challenged the evidence that she submitted if it were corrupted or otherwise an intentional fabrication, but the evidence she provided is a genuine temporary restraining order. The government then interpreted that the mere issuance of the restraining order was sufficient evidence pursuant to the law. And this is the other law that conflicts with the requirement that she be an actual victim. The final act perpetrated by the government is what I am challenging as a violation of those two separate laws. She could only possibly offer new evidence or testimony as to why she should be entitled to a fictitious address. Okay, so this is where I'm making the mistake. I'm imagining that the Supreme Court's trying to include her to give her an opportunity to present new evidence. But that's not what the Supreme Court is doing. She has a right to participate all of the procedural stuff, all of the technicalities, all of the statutory interpretation, all of that legal, the legal challenges that I am bringing to the Supreme Court's attention, even though they don't involve my ex's actual perception or her subjective idea as to her being a victim, even though I'm not really challenging any of that on this particular Supreme Court petition for writ of mandamus, she still has a right to participate in all the other stuff that I'm talking about. And so I'm imagining that she's going to be allowed to provide new evidence, but that's not really the case at all. This is not something where they review evidence at all. This is something where they're going to actually consider the legal contradictions that I brought to their attention, and that she should have a right to have some kind of input as to what interpretation should be accepted as well. So I am arguing that because she's not a necessary party, she cannot possibly be an indispensable party. And then the next section is that the impact of the case on her should be considered. She is an unnecessary party and would make more sense to simply issue the writ and allow her a grace period with which to file a renewed application before revoking her fictitious address. It's my belief that once the government is instructed by this court to strictly adhere to the requirements of the law and issue the fictitious address only upon being provided specific evidence, that the mere issuance of a temporary restraining order is insufficient and she would not be able to obtain one anyway. Okay, so this is all logical, but I'm wrong. She has a right to participate in the questions of statutory construction that I brought to the Supreme Court's attention. She's not just there to argue whether she should have a fictitious address in the general sense or because she has some kind of new evidence. She's also allowed to participate in the debate on it. It's a debate basically before the Supreme Court on how the law should be applied and how that intersects with the Constitution. And so all of that other stuff that I am not really thinking she should have a right to participate in, she does as a real party in interest. So in hindsight, if I had the experience then that I have now, I would have not filed this particular response. I would have just said non-opposition, she can participate, let her participate. In fact, I would have just included her in the petition, in the caption, as a real party of interest. Had I known then what I know now. Verified declaration in support, and this is just me swearing under penalty of perjury that all the facts alleged are true. Rule 5, certificate of service, which again is wrong. It's supposed to be under the rules of appellate procedure, not the rules of civil procedure. And I think it's a similar rule, Rule 28, I think. Anyway, the gist of this is that I mailed this document to the government's attorney. Secretary of State's supplemental response. What? Didn't they provide another? Why does it say supplemental? It makes me think that they filed some other response, but they didn't. This is the only one. Anyway, maybe that's just a typo on their part. Maybe this is just meant to be their response, and that's that. So as previously noted in an earlier docket involving the same matter, the case concerns my quest to learn the residence where my ex and son live. I love how he calls it a quest. Anyway, he ends up losing, so he's going to have to eat his words on that one. The government supplied a confidential address to her pursuant to the provisions of the law establishing the confidential address program. These are the two laws that establish the program. Me, by my action, seeks disclosure of the confidential address. This is correct. After my appeal was dismissed, no, it wasn't. It was affirmed. There's a difference. An appeal is dismissed for lack of jurisdiction. An appeal is affirmed because it was considered on the merits and decided the lower court was correct. So this he's using the wrong nomenclature. Falcone filed the instant action, a writ petition seeking to require the government to revoke her fictitious address. The court, by order dated December 28, 2011, directed both of us to file a response. He's going to argue that an indispensable party is a party that is necessary to an action, but for some reason cannot be made a party to an action. That's odd. So I guess the question is both whether she's indispensable and whether she's necessary. I should have probably split these apart in my previous response. If a necessary party is found to be unavailable, the court has to decide whether equity and good conscience allow the action to proceed. If in equity and good conscience the action cannot proceed, then the party is indispensable and the case has to be dismissed. A party should be joined if the party's absence would make complete relief among existing parties impossible, or if the potential party has a marital or a material interest in the subject matter. So this is it right here, subsection 2. My ex does have a material interest in the subject matter, making her participation in the lawsuit essential. And let's see what he's citing Rule 19A. Here, the third party, my ex, is unquestionably necessary to the action. Not only is her personal information, this is something that I mentioned earlier, I do believe that she has a right to participate in all of the legal disputes that are before the court. It's not just that she's going to provide additional information. Let's see. My very persistence in the matter is indicative of some less than wholesome motivation. What? So anybody who files a court case is doing so with some kind of bad motivation. There's no other way to deal with this except to file an action. So he's making it seem like the fact that I'm even trying to pursue the matter is somehow indicative that I'm a bad person. Okay, she's at least deserving to be informed that the issue of her confidential address is before the court, and she deserves a right to appear. As a real party in interest, she does. So this is true. She's not indispensable. By my own account, she's available for service. We exchange custody regularly. So he's basically saying that she's a necessary party, but that she's not indispensable. I should be directed to serve her in this matter if I wish to pursue it, and a failure to join her is fatal to the judgment. That's true. If the party is available and can be served, you should serve them and include them in the action. Party status is especially important in domestic affairs matters. And my suspicious argument that she's not necessary rings hollow, as I would have it the fictitious address could be revoked, and then she would be put to the task of applying for another. This is what happens anyway. No authority supports the position. Okay, in conclusion, the importance of the fictitious address to her safety and well-being, and that her... Okay, so he's saying that she should be included as a real party in interest. Order regarding briefing by the Supreme Court. Let's see here. On December 28th, the court entered an order directing an answer to the writ petition and instructing both of us to provide filings to determine whether or not my ex whether she's indispensable. We both provided responses. Having reviewed our filings, the matter can progress without first giving her an opportunity to participate. They conclude that the government shall have 5 days from the date of this order to serve my petition upon her with the entire accompanying record. That's weird. So the Supreme Court agrees with the government that my ex does need to be included in the action, but rather than telling me to include her, the Supreme Court tells the government to be the one to serve her. So the government is being ordered to provide my ex with the petition for writ mandamus, and the government is being ordered to serve her and file a proof of service with the court. Okay. As agreed in their December 28th order to expedite, which involves issues related to child custody, the briefing in the matter shall continue to proceed on the schedule previously established. Okay. Order granting telephonic extension. And it looks like the government asked for a telephonic extension, and they got it. These are unique to the Supreme Court of Nevada. I guess the Court of Appeals does it too. No other court does these, as far as I know, in Nevada. Maybe in other states they do. Anyway, the attorney can ask for what they call a telephonic extension. They basically just call up the clerk of the court, and the clerk just gives them the extension. They routinely grant it. And it's a short extension. I think it's like between 3 and 5 days. Any kind of extension beyond that, or an extension for a longer amount of time, the Supreme Court has to get involved and grant it. The telephonic extension is very popular. My understanding is that most of the time the attorneys ask for it. Why not? It's there for them anyway. And it's very easy. You don't even have to file a motion or anything. You just pick up the phone and call the clerk of the court and say, hey, can I get an extension? And that's it. They file this little piece of paper into the docket, and just like that, you get an extension. I don't know if non-attorneys can do this. I don't imagine they can't, but just have no idea about that. Going into the aftermath, I filed the petition, the appendix, the motion, 2 notices, and a response. So 1, 2, 3, 4, 5, 6 documents, but they weren't all free filings. All of them but one were free filings. The petition for writ mandamus was not a free filing, and I paid a $250 filing fee. So that's going to come to $250 in costs for me. The government filed 2 different documents. Those were both free filings, so the government incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have had to spend some time reviewing looks like 7 documents that I filed. For the petition, it's a pretty substantial document. To review it, probably 30 minutes, maybe let's just say an hour. It's a substantial document. I've cited a number of cases. And then there's the appendix too. So that could be another hour as well. So those are both pretty thick documents. So the petition and the appendix, that'll come to 2 hours of review. The motion that I filed, it's negligible. They probably didn't even care about that. Let's just skip that. The notice, I filed 2 different notices, which again, not a big deal. One of them is the notice of non-opposition. So again, I would say those are negligible. The response that I filed to the Supreme Court's order asking if my ex was a necessary and indispensable party, obviously they read it because they referred to it in their response, but I don't know if it would be worth more than 15 minutes. Probably 15 minutes. I doubt they would have spent more time on it than that. So right now we're at about 2 hours and 15 minutes. Then we have the government's notice of appearance, which is boilerplate. But they would have had to prepare that one, so that might have been 5 or 10, maybe 15 minutes. I'm going to just err on the side of nothing because I'm going to probably lump all of their time into the actual reply that they filed and prepared. The government prepared a reply with citations to case law, statutes about my ex being a necessary party. And it was a substantial document. It wasn't as long as the documents that they reviewed, but they would have still had to do research. I'm going to err on 2 hours for them to prepare that. So we're looking at 2 hours, 3 hours, 4 hours, and 15 minutes. And then we've got the 2 orders of the Supreme Court, 3 orders from the Supreme Court, 2 of them directing responses, 1 granting my motion. Negligible amounts of time, especially considering that we are up to 4 hours and 15 minutes. It's going to be easy to lump that all together there. So $250 an hour, we're looking at $1,000 and no, it's $1,062.50 for 4 hours and 15 minutes in attorney fees. And with that, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.